Hello everyone, and welcome to the Firearm Firm channel. By now, most if not all of you are aware that Governor Ron Desantis signed House Bill 543 into law. So, in this video, we are going to take a detailed look at how permitless carry will affect Floridians and those who are visiting the Sunshine State. Now, I'm going to warn you, this video is going to be one of my longer videos, but I want to make sure everyone stays on the right side of the law when it comes to carrying without a concealed weapon or firearms license, CWFL. Oh, by the way, I still think everyone wanting to carry a concealed weapon or a concealed firearm should have a CWFL, and check out my next video and I'll tell you why. Before we get into the meat of this video, be sure to show your support for the Second Amendment by clicking on the like button. And for those of you that have not subscribed to the Firearm Firm channel, now's the time to do so by clicking on that subscribe icon located in the bottom right hand corner of this video. On July the 1st, 2023, Florida Statute 790.01 will be amended to allow individuals who desire to carry a concealed weapon or concealed handgun to do so without first obtaining the government's permission, but they are still going to have to meet some of the exact same requirements needed to obtain a CWFL to carry. So let's take a look at the new amended statute and carefully break it down section by section. Florida Statute 790.01 is titled Carrying of a Concealed Weapon or Concealed Firearms and reads, subsection 1, a person is authorized to carry a concealed weapon or concealed firearm as the term is defined in Florida Statute 790.06 subsection 1 if he or she is A, licensed under Florida Statute 790.06 or is not licensed under 790.06 but otherwise satisfies the criteria for receiving and maintaining such a license under section 790.06 subsection 2 A through F and I through N subsection 3 and 10. So let's stop here and break this part of the statute down. The first thing everyone needs to know is how the term concealed weapon or concealed firearm is defined. Florida Statute 790.06 subsection 1 defines the term to mean a handgun, electronic weapon or device, tear gas gun, knife or billy, but does not include a machine gun. The statute allows you to carry a concealed weapon or concealed firearm in two ways, either with a CWFL issued by the Department of Agriculture or without a CWFL, so long as you satisfy the criteria for receiving and maintaining a CWFL under Florida Statute 790.06, subsection 2 A through F and I through N, subsection 3 and 10. In order to satisfy those requirements, you must be a resident of the United States and a citizen of the United States or a permanent resident alien of the United States as determined by the United States Bureau of Citizenship and Immigration Services, or as a consular security official of a foreign government that maintains diplomatic relations and treaties of commerce, friendship, and navigation with the United States and is certified as such by the foreign government and by the appropriate embassy in this country. Be 21 years of age or older. You cannot suffer from a physical infirmity which prevents the safe handling of a weapon or firearm. Have not been convicted of a felony. Have not been found guilty of a crime under the provisions of Chapter 893 or similar laws of any other state relating to controlled substances within the last 3 years immediately preceding carrying a concealed weapon or concealed firearm without a CWFL. Have not been committed for the abuse of a controlled substance under Chapter 397 or under the provisions of former Chapter 396 or similar laws of any other state unless you have been granted relief from firearms disabilities pursuant to Florida Statute 790.065 subsection 2 A4D or pursuant to the law of the state in which the commitment occurred. Does not chronically and habitually use alcoholic beverages or other substances to the extent that your normal faculties are impaired. It shall be presumed that you chronically and habitually use alcoholic beverages or other substances to the extent that your normal faculties are impaired if you have been convicted under Florida Statute 790.151 or have been deemed a habitual offender under Florida Statute 856.011 subsection 3 or have had 2 or more convictions under Florida Statute 316.193, which is Florida's DUI statute, or similar laws of any other state within the 3-year period immediately preceding the carrying of a concealed weapon or concealed firearm without a CWFL. have not been adjudicated an incapacitated person under Florida Statute 744.331 or similar laws of any other state unless you have been granted relief from firearms disability pursuant to Florida Statute 790.0652 subsection 2A 4D or pursuant to the law of the state in which the adjudication occurred. Have not been committed to a mental institution under Chapter 394 or similar laws of any other state unless you have been granted relief from firearms disability pursuant to Florida Statute 790.065 subsections 2A 4D or pursuant to the law of state in which the commitment occurred. Have not had adjudication of guilt withheld or an imposition of a sentence suspended on any felony unless 3 years have elapsed since probation or any other conditions set by the court have been fulfilled or expunction has occurred. Have not had adjudication of guilt withheld or imposition of sentence suspended on any misdemeanor crime of domestic violence unless 3 years have elapsed since probation or any other conditions set by the court having been fulfilled or the record has been expunged. Have not been issued an injunction that is currently in force and effect and that restrains you from committing acts of domestic violence or acts of repeat violence. Not prohibited from purchasing or possessing a firearm by any other provisions of Florida or federal law. Have not been found guilty of, had adjudication of guilt withheld for, or had an imposition of sentence suspended for one or more crimes of violence constituting a misdemeanor unless 3 years have elapsed since probation or any other conditions set by the court have been fulfilled or the record has been sealed or expunged. Cannot be subject to a pending criminal case, including a current arrest or being formally charged for a crime which would disqualify you from obtaining a CWFL. Have not been convicted of a second DUI or a similar law of another state within 3 years after a first DUI conviction or similar law of another state, even though the first violation may have occurred before the date you began carrying a concealed weapon or concealed firearm without a CWFL. The next two subsections of Florida Statute 790.1 is where I foresee a lot of people getting in trouble, and I will explain why in a moment. Subsection 2 and 3 of Florida Statute 790.01 outlines the punishment for carrying a concealed weapon or concealed firearm pursuant to the new law. If you carry a concealed weapon but do not have a CWFL or meet the criteria for receiving and maintaining a CWFL, then you are committing a first-degree misdemeanor, punishable up to 1 year in the county jail. Subsection 3 of Florida Statute 790.01 makes it a third-degree felony, punishable up to 5 years in prison for anyone who carries a concealed firearm without a CWFL or without meeting the criteria for receiving and maintaining a CWFL. For the most part, individuals with the CWFL never have to worry about knowing whether or not they have met the requirements needed to carry a concealed weapon or a concealed firearm. Why? Because they submitted an application to the Department of Agriculture, and when the department issued that person their CWFL, they let them know they're okay. Furthermore, if a person has a CWFL and subsequently no longer qualifies to have a CWFL, such as maybe they get arrested for a domestic violence charge, the Department of Agriculture will let that person know they are no longer qualified by sending a notice of suspension or revocation to the person holding the CWFL. Now, if you decide to carry without a CWFL, then all of the responsibility of making sure you are eligible to carry falls on you. So you better be 100% certain you have met the criteria for receiving and maintaining a CWFL and continue to be eligible to carry without a CWFL. Why? Because the fact you did not know something has disqualified you is not a defense to a criminal charge. Now that kind of leads us into the next part of Florida Statute 790.01, which is subsection 4. 4 reads that in any prosecution for a violation of subsection 2 or subsection 3, the state bears the burden of proving as an element of the offense both that a person is not licensed under section 790.06 and that he or she is ineligible to receive and maintain such a license under the criteria listed. Subsection 5 provides an exception while one is evacuating during a mandatory evacuation order issued during a state of emergency declared by the governor. Finally, subsection 6 of Florida Statute 790.01 allows for the prosecution of individuals who use an electronic weapon or device, dart firing, stun gun, or self-defense chemical spray during the commission of a crime. Now, I know I just gave you a ton of information for a statute that only has 6 subsections. Don't worry, I'm going to put a copy of every statute we cover in this video down in the description section for you to look at. Also, there's absolutely nothing wrong with rewatching this video over and over again until the information sinks in. Moving right along, we all know that currently if you are carrying a concealed weapon or a concealed firearm, you must carry your CWFL and a valid state-issued identification to present to a law enforcement officer upon their demand. That will not change after the new law goes into effect on July the 1st. But what will be required of those who carry under permitless carry after the law goes into effect? Well, Florida Statute 790.013 will require anyone carrying a concealed weapon or concealed firearm without a CWFL to just carry a valid form of identification with them while he or she is in actual possession of a concealed weapon or concealed firearm, and they must produce it upon demand by a law enforcement officer. Failure to do so will result in a non-criminal violation, punishable by a fine of $25, which is the exact same punishment for failing to produce a CWFL upon demand by a law enforcement officer. Subsection 2 of Florida Statute 790.013 puts anyone carrying a concealed weapon or concealed firearm without a CWFL on notice that they are subject to the same prohibited locations found in Florida Statute 790.06 subsection 12 as those who carry a concealed weapon or concealed firearm pursuant to Florida Statute 790.06. Florida Statute 790.06 subsection 12 prohibits the carrying of a concealed weapon or concealed firearm with or without a CWFL in the following locations. Any place of nuisance as defined in Florida Statute 823.05. Any police, sheriff, or highway patrol station. Number 3, any detention facility, prison or jail. Number 4, any courthouse. Any courtroom, except that nothing in this section would preclude a judge from carrying a concealed weapon or determining who will carry a concealed weapon in his or her courtroom. Number 6, any polling place. Number 7, any meeting of the governing body of a county, public school district, municipality, or special district. Any meeting of the legislature or a committee thereof. Any school, college, or professional athletic event not related to firearms. Number 10, any elementary or secondary school facility or administration building. Any career centers. Any portion of an establishment licensed to dispense alcoholic beverages for consumption on the premises, which portion of the establishment is primarily devoted to such purpose. Number 13, any college or university facility unless the licensee is a registered student, employee, or faculty member of such college or university, and the weapon is a stun gun or a non-lethal electric weapon or device designed solely for defensive purposes, and the weapon does not fire a dart or projectile. Number 14, the inside of the passenger terminal and sterile area of any airport, provided that no person shall be prohibited from carrying any legal firearm into the terminal, which firearm is encased for shipment, for purposes of checking such firearm as baggage to be lawfully transported on any aircraft. Or number 15, any place where the carrying of firearms is prohibited by federal law. Anyone who carries a concealed weapon or concealed firearm in one of those prohibited locations commits a second-degree misdemeanor, punishable by up to 60 days in the county jail. Come July the 1st, 2023, non-residents of Florida will be able to carry a concealed weapon or concealed firearm in the Sunshine State without a concealed weapons or concealed firearms license from their state, so long as they are a resident of the United States, 21 years of age or older, and the big one, they meet the same criteria for receiving and maintaining a Florida-issued CWFL. Finally, the last thing I think everyone should know about the new law is that when it goes into effect, anyone who is eligible to carry a concealed weapon or concealed firearm without a CWFL may carry a concealed weapon or concealed firearm on their person while in the interior of a private conveyance. Now, if you made it this far, I definitely think a congratulations is due. This is by far the longest video I think I've ever created, but House Bill 543 is something everyone needs to know about. Now, in this video, I did not cover a lot of other things that House Bill 543 covers. Why? Because the video is long enough as it is. However, if anybody watching this wants to know more about the other material covered by House Bill 543 that I did not go over in this video, let me know down in the comments section below. Also, if you have any questions about what we covered in this video, questions about things we did not go over in this video concerning House Bill 543, or any other Second Amendment related questions, be sure to leave them down in the comments section, or you can email your questions directly to us at questions@thefirearmfirm.com. If you think your question is too complicated or too wordy to leave in the comments section or email us, you can just give us a call at 321-332-6864. We are always happy to speak to our viewers. Until next time, stay armed and educated.